What is law?
Law is a set of laws that are established and applied by social or government mechanism to control conduct, and it is a topic of long-standing discussion in its exact meaning. It was defined differently as science and the art of justice.
What is classification of law?
Law in politics and legislation is a system of rules or norms that members of society try to follow. Usually, this is the rule of a country. If these rules are violated, the person who violates the rules may be punished or fined by the court. These rules are usually made by the government of the country so that its citizens can live, work, and socialize with each other. Sometimes, laws are also made by a group of like-minded people. The law is typically governed by a court system where judges hear disputes between parties and apply a set of rules to ensure a fair decision. The way in which law is administered is called the legal system, which usually develops according to a country's own customs. Most countries expect the police to enforce the law. Police officers typically have to be trained in law enforcement before they are allowed to do anything under the color of the law, to issue legal warnings and citation, to order a search or any warrant to make an arrest. Legal practitioners typically must have professional training in law before they are allowed to represent a party in a court of law, draft legal documents, or provide legal aid.
Classification of law has three types. The first one is a public law, the second one is a private law, and the third one is an international law.
Public law work as a way to regulate the relationship between individual and the states. Why is it important? Citizens can ask for judicial review if they are unhappy with a decision of an authoritative body.
Three types of public law. The first one is administrative law, the second one is institutional law, and the third one is a criminal law.
Administrative law definition. It is the body of law that governs the administration and regulation of government agencies. The administrative law system governs agencies, commissions, and boards. The public's interaction with administrative law most often occurs in connection with some type of public benefit, which has been denied or terminated. For instance, when a family's food stamp benefits are terminated because of a supposed program violation. Example of cases. Number 1. The murder of King Jong-nam. The murder of North Korean leader Kim Jong-un's half-brother, Kim Jong-nam, garnered much attention when the latter mysteriously collapsed at the Kuala Lumpur International Airport, KLIA, after being touched by two women. It was later revealed that the women, Indonesian citizen Siti Aisyah and Vietnamese national Tuan Thi Huang, smeared VH, a deadly nerve agent, on Jong-nam's face, killing him within minutes. Case 2. $2.5 billion scandal involving a Malaysian banks and taxpayer money. The gist of it is that Bank Bumiputra Malaysia Berhad (BBMB), the parent company of Hong Kong-based BMF, lost $2.5 billion. Local currency was still known as Malaysian dollar then, which it had loaned in stage to Carrion Group, a company run by a guy named George Tan. The money was invested in Hong Kong's property market that saw profit initially, but later went bust. Institutional law definition: to be made of organizations established by states and exercising public power. Most observers agree that private entities are excluded from its scope, as are entities set up within a single legal order. Criminal law definition: criminal law is only one of the devices by which organized societies protect the security of individual interests and ensure the survival of the group. There are, in addition, the standards of conduct instilled by family, school, and religion, the rules of the office and factory, the regulation of civil life enforced by ordinary police powers, and the sanction available through tort actions.
Private law. Private law which regulates the relationship between individuals in their private capacity. The state in private law, through its judicial organs, adjudicates the matters between the individuals. Here, the state is mere facilitator. It provides a platform for the individual to sort out their disputes, although it does not mean that state cannot become a party in the private law.
Three types of private law. The first one is a contract, the second one is a tort, and the third one is a trust.
Contract. Based on my understanding of the law of contract, as a general rule, the performance of contract must be exact and precise and should be according to what the parties had promised. In order to form a contract agreement that is enforceable by law, there were 6 elements must be fulfilled. First would be proposal or offer, acceptance, consideration, intention to create legal relations, capacity to contact, free consent, and lastly is proposal or offer. Section 38, bracket 1 of the Contracts Act 1950 provides that the parties to a contract must either perform or offer to perform their respective promises, unless such performance has been dispensed with by any law. Tort of law. Tort law is the branch of the law that deals with civil law, including lawsuits, but excluding issues involving contracts. Tort law is considered to be a form of restorative justice, since it seeks to remedy losses or injury with monetary compensation. In general, tort law falls into 3 categories: those complaints dealing with negligence, intentional harm, and an intentional but non-negligent act, known as strict liability.
The last part is trust of law.
Trust. A trust law is a trust. It's a fiduciary relationship in which a trustee gives another party, known as the trustee, the right to hold the property or assets for the benefit of a third party. While they are generally associated with the Edelweiss, trusts are highly versatile instruments which can be used for a wide variety of purposes to achieve specific goals. Each trust falls into 6 broad categories: living or testamentary, funded or unfunded, revocable or irrevocable.